Good evening. We are going to call the regular July board meeting of the Verona Zoning Board of Adjustment to order at 7:37 p.m. on July 9th, 2026. Would you please stand and join me for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Madam Secretary, would you please read the notice of this meeting and call the roll?
The notice requirements of the Open Public Meetings Act have been satisfied with respect to this meeting of the Township of Verona Board of Adjustment, which is being held in the ballroom of the Verona Community Center located at 880 Bloomfield Avenue, Verona. Specifically, the time and date were included in the public annual meeting notice. This information, along with the meeting agenda, was posted in the municipal building at least 48 hours preceding the start time of this meeting. The agenda and meeting documents can be viewed online on the Board of Adjustment's webpage on the Township's website. Please take notice that pursuant to NJ Public Law 2025, Chapter 72, the complete text of each legal notice of the Township of Verona, including all public entities under the authority of the Township, may be obtained or viewed by the public on our official state-registered webpage, veronanj.org/legal public notices. All meetings are recorded. Instructions on how to comment will be provided at the appropriate time. Those wishing to speak during any public comment period should only provide their name and municipality. Street addresses are not required. Please be advised that should a member of the public choose to state their street address, it will not be redacted from this recording. Mr. Tully?
Here.
Dr. Rees? Dr. Cortez?
Here.
Mr. Ryan?
Here.
Mrs. Murphy-Braddix? Here. Mr. Mathewson? Mrs. DiBartolo? Here. Vice Chair Weston?
Here.
Chair McGinley?
Here.
Board Attorney Massara?
Here.
Ms. Mish? Here. And Ms. Carpenter.
Good. Thank you. Let's start with some general information. This board deals with the issuance of variances from the Verona zoning ordinance. That ordinance establishes specific requirements for the land area in the township and regulates not only the uses permitted, but the size of the lots, setbacks required, parking, signs, conditional uses, and numerous other such regulations. An applicant is never entitled to a variance. Applicants must meet specific criteria contained in the state municipal land use law by satisfying certain legal standards of proof. The burden is on the applicants to show that they should be granted the specific relief requested. Depending on the type of variance requested, applicants will need to prove special reasons, undue hardship, a balance of benefits, and other criteria. These are legal proceedings. Public meeting notices have been published, neighbors have been notified, applicants and their representatives will provide sworn testimony and be subject to cross-examination. Any action this board takes at this meeting will be memorialized in a resolution document prepared by our legal counsel that will be reviewed and adopted typically at our next regular meeting. At that time, any variances granted will become effective. That said, we are a board that conducts its business in a fairly informal manner. Applicants are sworn in, tell us what they want to do with their property, and what they are asking the board to do. Board members will question witnesses, and then members of the public may question those witnesses. At the conclusion of the testimony, members of the public may make a statement regarding the application. After closing the public portion of the application, the board will deliberate and render a decision. We are up to item E on the agenda, approval of minutes. We have the minutes from our regular meeting of June 11th. And everyone should have had time to review them.
I'll make a motion to approve the meeting minutes from our June 11th meeting.
Thank you. And a second?
Second.
Thank you. All those in favor, please say aye.
Aye.
Any opposed? Any abstentions?
I abstain.
One. All right, takes us, it's the only minutes we have. Takes us to resolutions. We have a resolution 2026-15, which is for 94 Elmwood Road, 2 new HVAC units in the rear of the property. Okay.
I'll make a motion to approve Resolution 2026-15.
Second?
I'll second.
Thank you. Okay, all those in favor, please say aye.
Aye.
Any opposed? Any abstentions?
They're here. I abstain.
Okay, 3 abstentions. All right. That takes us through resolutions and old business. Next item on the agenda is the continuation of application 2026-10, 257 Pompton Avenue. Council, 6 of the board members are available to vote on this issue.
Yes, I understand that. I recognize I'm still under oath from the last meeting. Would you like to swear me in again?
No, sir.
Thank you. Chairman, are you ready?
Yes, sir.
All right, fantastic. Then I'll start.
Can you activate the microphone?
Absolutely.
Yeah, thanks.
Thank you. So this is the application for 257 Pompton Avenue. And as the board might recall, this is a 1.5-story structure located on Pompton Avenue. And on the Pompton Avenue side, there is what I'll describe as a horseshoe driveway that then straightens out in the back and goes to a garage. And from the Pompton Avenue side, you can reach a 1-car garage. On that side also, there is an entrance, I'll call it on the driveway side, to enter one of the 3 apartments that are currently established inside the building. On Vincent Place, there's a macadam driveway that you can go down, and it widens at the end to what I'll call a double-car length, and is a 2-car garage. From the back area, from the garage, is where the 2 bottom apartments normally enter their house, and that's also where the mailbox is located. So when looking at the survey that was provided to you from what I'll call the original submission in the application, you'll see between the garage and the building, there is a little walkway that leads to a patio, and that's where the mailboxes are located. So I'm just giving you an overview of what's currently existing. And also in the back, you'll see there are 2 patios to be used by, obviously, the tenants of the building. My application is being amended to change none of that. The outside will remain exactly the same. What I have provided to the board is the plans, the current condition plans and the proposed plans for the interior of the current house. So I could walk you through that, starting with what I'll call the common entryway. When you're looking at the plans, that would be to your left. When you come in the door, that's the door from Route 23, I'll call it. There's a common entryway there. There's a little foyer, and then you'll be met with a door to your right and a door to your left and stairs directly in front of you. So if you walk in that door and you make a right, you'll go to the first apartment. It's currently set up with a living room. Off of the living room, there's a bedroom, a bathroom with a sink, a toilet, a full-size tub, as well as a walk-in shower. When you go back into the living room, you then walk into a dining room, a kitchen, and behind the kitchen, there is a laundry room. So that's just a long hallway and has a washer and a dryer in it currently. And then you can see the steps off the kitchen leads to the back patio. And if you come out of those steps and were to make a right, that's where the garage is located. That's where the mailbox is located. Just to the right of those steps, not on the garage, actually on the building. You have the multiple mailboxes screwed to the wall there. So that's the first apartment. Second apartment, again, if you come in the common entry, you would now make a left. To your left is a bathroom with a sink, a toilet, and a tub shower, I'll call it. Then you have a living area. And if you walk down a hallway where it says apartment number 2, there's a large bedroom, also has a walk-in closet, and there's a closet in the hallway. Again, if you come out of the bedroom, go down the hallway, you'll see there's a small dining area, a kitchen, and another door leading to the back patio. So that apartment has 3 entrances/exits. One's off the living room, the common entry, they can go out that way, and then they go out the back patio. Now, if you go again to the common entry and you go up to the existing second floor, you'll see when you come up the steps, when you go to the left, there is a bedroom, as well as what I'll call a very large attic storage area. And directly in front of you, or maybe off to the right slightly, you'll have a bathroom with a sink, a tub, and a bath. There's a living room, a kitchen area, and 2 other bedrooms. So the top floor apartment is currently set up as a 3-bedroom. That is exactly how the apartments and the house is set up now. When I say apartments, it's clear to me that these were used as apartments because all of the doors to enter the apartments have, deadbolt locks and things of that nature. Now, the only thing missing from the 3rd floor apartment currently to be used as, I'll call it a real apartment, is a working stove. So the kitchen currently has a microwave, a refrigerator, and a sink. There is no stove, though. So if this was approved, I would get the permits from the township, whatever's necessary, whether it's electric or plumbing or whatever has to be done, plumbing meaning gas, to make sure the stove is installed properly, a working stove is installed properly. Now, with regard to the current plans, those are the current plans. Now, if we look to the proposed 1st floor area, the only change I would be requesting is to make, when you come into the common entry area, you would actually enter into a bedroom. We would change the door location of that bedroom and the door location to the other bedroom, so both the 1st bedroom and the 2nd bedroom could enter that bathroom. Then you'd have a living area, a kitchen, and a laundry room. So the only thing I'm asking to do is seal a door and put 2 new doors in, I'll call it. So my application is to, just to be clear, keep the existing property in the exact same condition, other than improvements. I plan on planting flowers and whatnot. But as far as building, keeping the existing building, the driveways, all the same, exact same location. There'll be no changes from the outside. In the inside, I am requesting the ability to make one apartment a 2-bedroom apartment versus the current setup, which is a 1-bedroom apartment. Now, I've also received on July 8th, 2026, at 9 a.m., a letter from the township with the engineer's comments that I'm sure you guys have. So I'd just like to go through the 7 comments to make sure the record is clear. It says, number 1, that I shall provide testimony regarding the condition of the existing building and proposed improvements. Again, I've done that. With regard to the existing building, there are no improvements. With regard to the interior of the building, there is an improvement that I'm asking for, which is, I'll call it the door change, so we can change one apartment into a 2-bedroom apartment, which would also obviously make, I'll call it the main entrance, to be in the back where they enter through the kitchen. And I can tell you now through experience, that's where people go to anyway, because that's where they park. They enter into the kitchen on both of the 1st floor apartments. You wouldn't use the front door because there'd be no sense in walking around the house. Applicant shall confirm, number 2 of the letter from your engineer, application shall affirm testimony, no exterior improvements or regrading are proposed. That's correct. As I indicated, there are no proposed exterior improvements. Applicant shall perform, number 3, the proposed improvements will cause no increase in the impervious coverage. Again, I'm making no changes, so there'll be no changes to the site plans you've been provided. Number 4, applicant shall provide testimony regarding site existing drainage patterns and if the dwelling currently experiences any flooding issues. I've owned the properties for about 1.5 years now, and while I understand that there are some weather issues on neighboring properties or on Vincent Place itself, I've experienced absolutely no flood issues. There are I believe two, but I know at least one, sub pump pits. Actually, there's two sub pump pits in the basement. There are no pumps and there is no water. So not only don't I have flooding problems, while I probably would one day if you approve this application, stick some pumps in there just in case. For a year and a half, it's been dry, and they don't even fill up with water, so I've never been concerned about it. And that's how I purchased the house, and it was dry when I did my, walkthroughs and whatnot, so I've never lost any sleep over that. Number 5, applicant shall provide testimony if any new mechanical equipment is proposed, HV units, generators, etc. No, there's no changes to the outside. There's no current HVC units or anything like that being sought during this application. Number 6, it talks about 6 parking spaces are required for the dwelling as it's currently said, but as your engineer indicated, there is sufficient parking available on the site, which the detached garage and the driveways. And again, just to make sure the record's clear, the detached garage is actually has 3 garage doors. 2 garage doors face Vincent's Place, and there's almost like a rear garage that faces Pompton Avenue. So although it's one building, it's a large, I'll call it a large garage building. Number 7, roof leaders and foot drains shall be directed onto absorbent surfaces such as grass, mulch, rock, soil. I was there after receiving this the other day, and I actually noticed, I gave some of the neighbors a tour of the property, and I noticed that, in fact, the leaders are, just going into the grass and whatnot. And again, for the year and a half I've owned the property, I have not noticed there's been no flooding issues certainly inside, but there's been no ponding or pooling of water anywhere on the property that I've visually seen. And I can also say that if you go back to the survey, there is it's not on, it is on the survey. On the property, there's actually a sewer grade. And I can say that I've never seen any water go into the sewer grade. I'll call it via a stream or whatever. Although the sewer grade's there, the only water entering the sewer grade that I've observed is, rain kind of going directly into the sewer grade, because obviously rain will land on top of the sewer grade, but there's no water issues on that property that I'm aware of. Unless the board has any questions, I think I've described the amendment to my application, so I'm just requesting that the board allow me to use the property the way I understand it's been used for the last couple of years.
So,
And just to confirm the point where you said there is no new HVAC units, the building itself currently has HVAC units?
No, it is not. There's no central air.
Okay, so it's window air conditioning?
We're in the air conditioned, that's correct.
Okay.
so I guess what variance are you seeking now if you're keeping everything basically as is? Was it previously not approved for residential use? Is that?
Although I didn't do my own search, my understanding by speaking to the zoning officer is that it's never been approved as a 3-family, even though it's been used that way.
This is a D1 variant.
With the one unit not having a stove, that I believe when we researched it may have been listed as a mother-in-law suite or something like that. So this would be a use variance for 3 separate full units, not any kind of a mother-in-law suite.
How do you envision the parking with the garages and the driveway? Are you assigning spots for each unit? How is that going to work?
Well, it would be my plan to assign spots. So, to further describe the location, if you don't recall, you're not familiar with the location, is directly in front of the property. There's also a bus stop. So I would assign parking spots based upon, I'll call it who needs the parking. So I wouldn't right now say, oh, apartment number 1 gets this spot, apartment number 2 gets this spot, apartment number 3 gets this spot. So I would wait to see who came, who rented what apartment, and how many cars they have to see where it makes sense and where they should park, would be my plan. But certainly, I'll call it the apartment, when you walk in the main door to the right, would have, in my mind, a parking spot off of Vincent Place, because that makes the most sense for them. The other 2 apartments could be on, I'll call it the Route 23 side. because that parking would make sense for both of them.
Mr. Chairman, I guess I have just a clarification point either for our zoning officer or our attorney. In looking at the original application, since this is now becoming all residential, a use variance would still have to be granted because it's currently C2?
Correct.
Okay.
That's the nature of the D1 use variance.
Okay. But if I understood you correctly, Mr. Alloy, it's been de facto that way? Can I use that terminology? Since you owned before you owned the building, it was?
Yes, my understanding is before I owned the building that it was completely residential. That's correct.
Okay.
And in fact, it's dwindled now because I've owned it for a year and a half. There was tons of mail for all different people. You could tell it was used as a.
So there
as a
really
rent.
hasn't been an office, for at least in your memory, there has not been an office or a professional building, office space in that building for.
My understanding is the last time an office space was in that building is when the owner I bought it from moved his office. It was a vac shop from Verona to Caldwell.
Okay.
And my understanding is that's happened many, many years ago.
Okay.
But that's a guess. I don't actually have an independent recollection, even though I live in town, of the history of that building.
Kathleen, can you shed any additional information on how that building's been used?
There were several resolutions that went along with the building. They didn't seem, from my recollection, I don't have them from you, that was anything recent that it was used as a business. And the only historical is exactly what I had found out, what Mr. Aloya just said, that at one point, when the person who moved in there, that they used it as their office. But the last offering of it was all residential.
Okay. So essentially, we're taking the last office space and making that a residential unit. Is that inaccurate? The last space that was possibly used as the individual's office is now going to become an apartment.
Well, my understanding of speaking to the zoning officer, and again, correct me if I'm wrong, zoning officer, is that it's also not recognized as a two-family. So you're technically going from, I guess, a one-family to a three-family?
Okay.
From a technical last approval, I'll call it.
Right. The last approval, I believe, was for one apartment and then a mother-in-law suite and then maybe an office. It wasn't really clear. So it was not a multifamily. It was not a 3 full unit residence.
Okay. So I'm just trying to get myself clear. So if we are willing to accept Mr. Aloya's latest plan, how many variances would we have to authorize?
One.
Just the one?
One use variance, turning it into a multifamily 3-unit building.
Okay, thank you.
I'm still a little confused as to what the catalyst is that we're looking at here. Like what prompted this? Because it's a pre-existing non-conforming use, then we're not expanding it.
It was never approved as a multifamily use. So therefore, especially turning the 3rd unit, putting the stove in, and turning it into a full unit, you have to say that it is a 3-unit multifamily dwelling.
Okay.
Because it was never approved as one.
And even if it had been, it was abandoned. The property has not been used for over a year, so the property may have been used for a different purpose, but the previously allowed use was abandoned.
Just want to, might want to just double check with your architect because this kind of kicks it into a different category of classification per the building code. So just heads up on that.
I understand.
Now, this is a real hypothetical, but if Mr. Aloya decided, if this was approved, decided to sell the building, okay, and someone wanted to come in and return it to its original zoning purpose, would there be any problem with that?
Not if it's a permitted use. If it's not permitted, then a new variance would be necessary.
Okay. But if theoretically, if someone wanted to turn it into a doctor's office and leave, on the...
Well, the doctor's office is permitted, but you can't go back to a previously allowed non-conforming use without coming before the board.
But if it was a conforming use before we gave him
If the variance,
If
then
it's
it
still
would be,
conforming.
then it would be okay.
Yes.
Okay, thank you. And the doctor's office is not allowed to C2.
Okay.
Well, originally you were going to put your law office in there. Professional office is allowed. So if another lawyer bought it from you and said, I want to put my law office in there, they should not have to apply then for a use variance if they decided to. As long as they met, it depends on the conditions in the apartments or whatnot, because I had to because of the conditions of the property.
Right.
So I think they probably would actually have to come, but if they left the building the same way it is, they probably wouldn't, but that's hypothetical.
Okay, thank you. I realize it's hypothetical.
Is there any other board member who has a question of the witness?
May I ask the witness a couple questions? No, that's why nobody had any questions, so.
You're good.
Mr. Lawyer, with regard to special reasons, this may have been testified earlier, but now the application has changed. So is it your testimony that to allow this would establish appropriate population densities in town?
Yes.
Okay. And is there any, with regard to negative criteria, do you see any substantial detriment to the public good?
No, in fact, I would argue to the contrary, that it's been used that way, although not with approval, and there has been no detriment to the public good.
Okay, and would it impair the intent and purpose of the zone plan or the zoning ordinance?
No. So the zoning plan and the zoning ordinance in the township encourages additional units of residential units.
Okay.
And this, in fact, although it wouldn't be low-income units, they would be what I'll call affordable from a monetary perspective. They're not high-end units.
Thank you.
Just to make sure it's there, we're back here because there had to be a discussion with the residents. Was that discussion had? Is that why you're here? Is that why this is here in front of us?
Yes.
No,
So,
sorry, the neighboring residents on.
yeah, so the update with regard to that, I'm sure you heard from some of the residents, are that I met with the residents after our last meeting here. I also reached out to one of the residents, a different resident, actually the resident immediately, his house is right next to the property, did reach out to me. I gave him and another resident a tour of the property yesterday. I answered all of their questions, and it's my understanding that some of the residents are satisfied with the application and are happy. I was also requested to withdraw the application and keep the property exactly as it is. And I explained that that is exactly what I'm before the board to do, is to keep the property exactly as it is, but I need permission to do so, to use it in the way that it's currently set up. So I'm sure we'll hear from the residents, but so I understand that some might be amendable to it, some might still have questions, or maybe after my testimony, they now understand I'm not changing anything. I don't know. But yes, I did reach out, conversations had.
Thank you. I just want to make sure that you took the steps that you needed to come back to.
I did the best I could, absolutely.
Is there anyone from the public who has a question of this witness at this time? If you would, please come up to the microphone, name, town.
Hi, I'm Anna Fusara, Verona. So I'm a neighbor and you never reached out to me, correct?
So I reached out to, I'll call it my,
Did you reach out to me, sir?
I can tell you how I reached out so the record's clear.
Can you just answer my question, please?
Sure, I'll answer your question. No, I
Thank
did
you.
not specifically
Okay.
reach out to you.
Okay,
I reached
have a
out
few
to,
other
Chairman, I'm
questions,
not done with my
please.
answer.
Well, I asked you and it was answered, asked and answered.
But
I asked if you reached out to me, you said no, asked and answered. Okay.
That's all we need to know.
So I feel a little bit like you buried the lead, and I'm so glad that it was tried to be explained. You need a use variance, correct?
That's correct.
Okay. You never said that in explaining where the bedrooms were, so you need a use variance, okay? When you purchased this single-family house at 257 Pompton Avenue for $775,500 a year and a half ago, did you know what the zoning was?
I think it was $777,500.
That's what I just said, 777,500.
And I don't believe that's what you said, but I
I
apologize.
believe that is what I
I
said.
apologize if I misheard
But
you.
that's neither here nor there. The question is, did you know what the zoning was?
No, I did not.
Okay. What is your profession, sir?
I'm an attorney.
Okay. If a client came to you and asked your advice in purchasing property, Would you advise them that it
So-
was not necessary?
Your line of questioning is with regard to his testimony.
Okay, and I'm
But
asking
this
about
is-
the zoning.
Well, the purchase price of the house is not, of the property is not relevant.
I wanted to make sure that
Mrs.
I was
Fasaro,
talking about the
please,
right
please.
property.
Okay, now, you know what the property is?
Yeah.
Okay, and when you ask questions of the witness at this time?
Yes.
The questions are limited to his testimony.
Okay.
Okay.
Is it your testimony that someone should not be aware of zoning when they purchase a property?
Mrs. Fasaro, that's not his testimony. He did not testify.
We're calling
about-
him counselor, so he's a lawyer, and it's important to know
Mrs. Fasaro,
what his
it has no-
intention
It has
was.
no relationship
I'll move
to
on.
his testimony.
I'll move on.
Okay.
What was your intention for the use of the property you purchased?
My intention has changed multiple times. Do you want to go through all the intentions?
No, I said, what was your intention when you purchased the property?
To find a good use for it.
What was your intended use at the time you purchased the property?
I had multiple ideas. I didn't have a specific idea that I was, I'll call it guaranteed or going forward with. I did.
What was your optimal use?
Mrs. Fusaro, please do not badger the witness. And
I'm
we've all-
just trying to
we've all
find
sat
out
through
what his
these hearings.
intention was.
We've all sat through these
Okay,
hearings. We
I'll move on.
understand he wanted to use it for a law office. He wanted to use it
Well, why
for,
can't he answer that?
because it's been done, remember?
Okay.
You
Did
were the
you
one who
think-
said, asked and answered.
Did you think, okay, I'll move on. Did you think that you would need a zoning use variance when you purchased the property?
Yes. No matter what I did with it, I thought I was going to use the zoning use. That's correct.
So you did have an intention that you knew that that property was not zoned for the use you intended it for?
No, my understanding was, and I believe it's played out here, is that there's different conditions and whatnot on the property that would require approval of this board based upon setbacks and whatnot, because the property is, I'll call it an odd shape.
Mm-hmm. What's the odd shape have anything to do with it?
It makes it harder actually to place all your setbacks and whatnot.
What does
And-
that have to do with the zoning of it, though? The
Well, that has to
C2
do-
zoning?
That has to do with requesting this board to approve whatever you do.
Okay. Can you explain to me what a high bar means when applying for a zoning use variance in your understanding?
I cannot because it's not relevant to
Okay.
my application.
Okay. You believe that a use variance does not require passing a high bar? Is that your understanding?
Again, I'm not going to provide you legal advice that your question does not.
Okay, we've been told multiple times that it does, so, okay. Is it your understanding that the board cannot grant a variance simply because the use would be profitable for you?
Again, that question doesn't have anything to do with my application, so I'm not going to answer the
Okay.
question. Thank you.
Okay.
And
Do you-
for the record, Mrs. Fusaro, the board cannot consider family or finances in its decisions.
Well, I don't understand your point.
It doesn't matter whether it's profitable or not profitable for him.
Correct, that's my point. Do you understand that you must show why the property cannot be used for any of the uses already allowed in its zone?
Thank you, but that question doesn't have to do with my
Okay.
application. so
Can
I'm
you
not gonna
tell me if you can or cannot, is it impossible for you to use the property for its current zone?
answer. Again, that doesn't have to do with my application. I'm asking for a variance.
You're asking for a use variance. Can you use the property as it is currently zoned, or is it impossible for you to do that?
It's not impossible to do
It's
anything.
not possible?
It's not impossible to do
Okay.
anything.
Thank you. It's not impossible. So why wouldn't you do that?
Again, I'm here to ask for a use variance.
Why would you not use it for the zoning that it's currently in?
Because this is the way the house is currently structured, and this is how I would like to use the house, and that's why I'm asking for permission from this board to use it.
Okay, so you have no reason as to why you can't use it for the zoning it currently is, correct?
Other than the reasons I've testified to during
Which
the
is what?
questioning of the board.
I haven't heard that.
Well,
Why can't you
I
use
think-
it as it's currently zoned?
so other than the answers I've provided the board, there are no other reasons.
I'm asking you to provide that answer to me.
I've already, it's asked and answered.
I didn't hear your answer.
Okay, well,
Why can't you
I'm
use
sorry.
it for as it's currently zoned?
Again, the reasons that I want to have this change are not relevant to my application. The reasons why I've asked for the change, I've testified to.
You need to provide a reason as to why you cannot use it as it's currently zoned.
Just so for the board's clarity, that is not a criteria under the issuance of a D1 variance, nor would the applicant have to show that he can't use the property for which it is owned. That is not a criteria under the municipal land use law.
May I ask the question, though?
Proceed. I just didn't want the
Can
board.
you tell me why you cannot use the property as it is currently zoned?
Ma'am, I asked and answered your question. You asked me if it was possible to use the property as it's zoned. It is possible.
That's not my question. I want to know why you're not going to.
It's not relevant to this.
It's relevant to me. I'm asking you.
Sarah,
Sorry.
your time is
Okay.
your time is almost up.
thank
So if you have other questions, please ask.
Is there anyone else from the public who has a question of this witness about the testimony that he has presented this evening?
Hi, my name is Anthony Gardner, Verona. Just one question related to the use variance. So if Mr. Aloya ends up selling the property,
Mr. Gardner, you've been here many times, okay? A question of the witness for what he testified.
Okay.
Okay.
Do you know if you sell the property, if the use variance that's approved, say for you, does that carry over to the next owner?
My understanding is the answer to the question would be yes. So if I were to get this use variance and sell the property, the next owner can keep it the exact same way and use it as long as he continues to maintain it that way.
Okay, thank you.
Is there anyone else from the public who would like to ask a question of the witness? Seeing none, I would move, is there anyone from the public who would like to make a statement about this application before the board begins deliberation? Mr. Sorrow?
Mr. Sarah, since you are going to make a statement, will you raise your right hand? You swear or affirm that the statements you make are true to, so help you God.
I do.
Thank you.
In my opinion, approving this use variance will change the character of our neighborhoods. There is nothing different in this variance request than the last one. It's an apartment building. It's at the end of a street that only has one family, single family houses. And we want to put an apartment building at the end of that street. It's not a good idea. It will change the character of the neighborhood. Additionally, it will set a precedent for other properties that are at the end of streets with single-family houses, just like Vincent Place. Other properties will apply for a use variance to build an apartment building, and will use this decision as a precedent to have theirs approved. Some of my neighbors might be short-sighted in not realizing this. I am not. Please don't approve this variance.
Thank you. Is there anyone else from the public who would like to make a statement about this application? Seeing none,
I'm sorry. Just real quick, Anthony Gardner, Verona.
Do you swear or affirm that the testimony and statements you're about to make are the truth?
Yes.
Thank you.
Thank you. I also share concerns about the precedent this sets with future owners of this property and with further development in that stretch of Pompton Avenue, which is already extremely high traffic, and there's safety concerns with traffic and accidents in our intersection this past week. So that's really my only concern about it. I do really appreciate that Mr. Aloya has reached out to us, some of us, and is trying to be reasonable, is trying to find common ground. So I do really, really appreciate that, sir. My only concern is changing that zone and what that could, the implications it could have on the future. But I do thank the applicant for his consideration and trying to work with us to find common ground. Thank you.
Thank you, Mr. Gardner. Is there anyone else from the public who would like to make a statement? Seeing none, I would close the public portion of this application and move to board deliberation.
Mr. Chairman, I need to interject again. I apologize. It's important for the board to be aware that we talked about in the beginning of this application that Mr. Loya is the township attorney. This board is supposed to give no deference to Mr. Loya that he is because he is the township attorney. And on the flip side of that, Mr. Loya has no additional burden to prove the merits of a use variance because he is the town attorney. The other thing, Mr. Chairman, the issue of precedence has come up and has come up in the past in front of this board. Yes, an approval would run with the land, obviously. If Mr. Loya were to be granted the variance this evening, subsequently sold the property, the subsequent user could continue to run that property, to use that property as a three-family. However, the precedence it's an unusual concept when you're talking about variances. This board is not supposed to zone by variance. It's up to the governing body to create the zoning ordinances. When a variance is issued, theoretically, it is supposed to be more difficult for an adjoining property to obtain the same variance. Because, as you know, this body reports to the governing body as far as what has been presented, what has been approved, and what has been denied. So the subsequent application, if the governing body does not change the zone, it is to be presumed that the governing body does not want to change the zone. So the next variance application should have a greater burden because the governing body, by its silence, has spoken. So precedent should not come into as a factor into your decision making.
Thank you, Counsel. And can you confirm for the board and for the public's education that the use variance is tied to how the applicant presented it, and it cannot be expanded upon in terms of, for example, being made into a 4-unit apartment or an 8-unit apartment? It would have to stay with basically the plan that was presented.
No, in fact, any change whatsoever to a non-conforming use would have to be presented to the board. If Mr. Loya came in and said, I want to do a 10 by 10 addition, but not create another apartment, that would be an exacerbation of the non-conforming use. So he would have to come for variance approval. Changing the number of families, certainly, but changing anything to the exterior of the building would be considered an exacerbation, and he would have to come back to the board.
Okay. Thank you.
Okay.
Maybe I can ask a question or actually, we haven't started deliberation yet for that.
Well, we're about to start.
Well, you can officially start, and then I'll ask.
Thank you. Your question is for
Well,
counsel?
either for the zoning official or for Mr. Loy, who's ever better. Okay.
But
There's a lot of the-
before we
a lot
get
of
into
the-
that, can I go
Sure.
through something I jotted down? Because I did review the tape from last time, so I listened to the whole thing. And I just...
Bless you. Go ahead.
Thanks. So I am also an architect. I'm in a unique position because I've been a board member, I've professionally testified on behalf of applicants, and I've been a member of the public. I certainly understand what it feels like to have a project encroach into your daily lives as a member of the public, and I understand the fear of overdevelopment and the prospect of change. But I also understand the energy and effort that goes into each and every one of these applications by the professionals and the applicant. There are too many decisions that are to be made, and the public is not necessarily privy to those. It doesn't mean that they're incompetent. It doesn't mean that they're liars. Not all decisions are shared. And as a board member listening to this criticism, it troubles me to know that there's a lack of understanding on both sides that should be communicated. An applicant is fully entitled to develop his or her project, no matter what the motivation is. And certain comments that suggest that the public doesn't understand that there are protocols outlawed in the municipal land use law that applications are allowed to and required to follow. I encourage all members of the public to pay attention to not only this hearing, but to all hearings and anything related to land use, including the policies and procedures, if this is a concern of yours. Nobody has made any reference to the emergency services building that might go up just a couple lots down, nor have they made any reference to the master plan and the fact that the King's Plaza may be further developed one day to an extent that would make this project seem quite small. So I encourage everybody to pay attention, much more so than just this one-off application.
And for the record, we don't set precedent. Every property we consider on its individual basis. So, given this property, the application that's been here for the last 3 months, the various changes that have gone on, and where we have arrived at today, we're looking at a single use variance to consider at this point. What are your thoughts?
I mean, I think Mr. Aloya is kind of stuck between a rock and a hard place, trying to accommodate, certain personalities and certain opinions, where one neighbor says, well, you're destroying the character of the neighborhood. And yet this is, it already is a very, very busy street. Developments happen along busy streets, as they should. You don't want to plop this project in the middle of town where there's single-family homes. That doesn't make any sense. So, I give you a lot of props for accommodating what you've accommodated. And I think that it is appropriate for where it is.
Just to my understanding, and based on, I think, a comment that you made previously, given the existing first and second floor plans and what is being proposed, that would essentially allow for work to be done and the permits and the checks, the safety, all that, to essentially go through the checks and balances in that construction process for close to what is already there, but done correctly to today's codes, to today's standards, with essentially next to nothing else changing in and around the property. So it's, if anything, almost as close to a safety check in my mind to what's already on the property. That's just how I see it. Just based on your by shifting over, adding a bedroom, it's almost like a reassurance that we're actually going to get checks and balances through codes, through checks, through permits on the work that's going to be done versus what's already there at this point, without the dramatic changes that we saw in past applications. So I don't know. That's how I feel about it. So.
Okay. So what I think came out during some of the testimony at the prior meeting and was sort of expounded on here. This may sound like a very elemental question, but what is the purpose of a C2 zone? In other words, what is permitted currently there? Can we succinctly describe? And I think, once again, to Ms. DiBartolo's point, I think we need to edify the public, as to what the current definition of that is, and if we are going to deviate from that, which if we allow the use variance, we will be doing. Correct, Council? Is that
That's what the use variance is, sure.
okay?
Well, Kathleen can tell you.
Kathleen, yeah, okay.
So a C2 is a professional office and business zone district. The principal permitted uses are commercial and professional offices, commercial schools offering instruction in dance, music, fine art, and similar pursuits, and family daycare centers, and actually not in this one, but was added was assisted living as well.
Okay, so, but there was always been, in essence, there've always been some residential units, from what my memory is, attached to this particular structure.
So correct, there are three previous resolutions that go with that, and every time there is a new resolution, it supersedes the one before it.
Okay,
So this would make it a multifamily, 3 units, couldn't change from 3 units, use.
okay.
And that would be its current use. You wouldn't go back to any of the other approvals that were done before. It would stay with that. Every time there was a different resolution,
So
then it
so there
changed.
were other variances
Yes,
passed prior to the,
yes, nothing.
Those variances have nothing to
Nothing
do with this
They have
application.
nothing to do,
So,
and
right, Council, I'm just trying to,
Well,
Right.
but let's leave that out of this conversation because we
And-
don't want it to interfere with.
because the other
And-
thing that if you look at that street, let's be real, to the right of Vincent Place is also a C2 zone. And it happens to conform to the definition that, I think for the most part, that Ms. Misch just read. There is I think it's a dentist office, and there may or may not be, they're so close together, it's hard to just take them in a, in a standalone sense. So I think basically, I know we can't project into the future that the dentist is going to sell the building and come in to ask for the same type of variances, but this is I think this is the elephant in the room, if I can put it that way. And I know we're not supposed to take that into account, but.
Right. Just for the record,
Yeah.
there are only 2 areas in town that are Zone C2. One is on Grove Avenue, the Animal Hospital, and the 2 historic buildings next to it. And the other is along Pompton Avenue from Vincent Place to Claremont.
Okay, and please don't take this the wrong way, but this board has already eviscerated the C2 zone on Grove
Grove
Avenue. Essentially. Okay. That's really de facto been eliminated, right? Is that an accurate statement?
Yes.
Okay, thank you.
Other thoughts on this application?
I'll just say it. I agree with what Dr. Cortez said from the safety aspect. 3 units, I think, is going to be very appropriate for where it's located, as moving from the single-family homes on Vincent Place to the busy, Route 23 State Highway. I think 3 units is very reasonable. It's not going to have kind of negative impacts from a traffic perspective. Even I think if it was some of the approved uses, you would actually see more cars and traffic and whatnot than the 3 units.
Other opinions? Mike?
I agree with everyone too. I think it's appropriate for the space.
Oh,
Yes, so I've been part of these meetings, sorry I'm late, I do apologize. I do really think that
he did participate.
this application has met a lot of the concerns that people have. I think it's toned down from what it was, and I can see how the entrance into on and off of Pompton or Route 23 is not going to be it's really not going to be that much of an issue with just the 3 apartments. So I do think that this has been a very good compromise from what has been presented in the past, and I look forward to seeing what the vote here.
Okay. Has everybody had an opportunity to make their statements? If so, I would entertain a motion to move this along.
I'll make a motion to approve application 2026-10, 257 Pompton Avenue.
I'll second that motion.
Okay, we have a motion and a second. Madam Secretary, may we have a roll call vote?
Mr. Mathewson was unable to vote because he was not here for the entirety of the start of the meeting.
Okay. And also, Mrs. Murphy Braddock will not be voting. However, Mrs. DiBartolo did watch the recording, so she will be eligible to vote. Mr. Tully?
Approved.
Dr. Cortez?
Yes.
Mr. Ryan?
Yes, and I'd like to explain my vote. Okay, after we finish.
Mrs. DiBartolo?
Yes.
Vice Chair Weston?
Yes.
Chair McGinley?
Yes. By my count, the motion passed with at least five positive votes as required. Six. Okay.
Chairman, I may. I just wanted to say thank you to the board for listening to me. I also want to thank the public, including the naysayers. I hope that I made the changes that help you live, and I understand some people still aren't necessarily satisfied with the property. I hope that the flowers and whatnot that I plant make the area look nicer, and that they come to actually enjoy the property. But thank you very much for all your time and energy. I know this has been a long application and one that I've started at one spot and ended somewhere completely different. So thank you for your time.
Not altogether unusual here.
I think it's worth saying, that most applicants wouldn't go to such extents to make accommodations, so.
Mr. Chairman, I'd just like to explain to the public that I voted yes because they didn't want to penalize the applicant over what I consider to be a horrible ordinance. Okay, I think that placed too undue a burden on him if he had to conform, if he had to restrict himself to all of the requirements of that particular ordinance, and I guess that's why this board exists. Thank you.
Exactly. All right, well, don't follow me on any of the gambling ones. I had that one down as a pretty much over by 8 o'clock. So we will move quickly into application 2026-15, 17 Douglas Place. The applicant is seeking approval to install new HVAC units. If you would, please remain standing. Council will swear, no, at the table. Council will swear you in, and then you can sit down and get comfortable.
Can you both, one at a time, state your name and address for the record, please?
Gianna Bavaria, 17 Douglas Place, Verona.
Nicholas Gaviria, 17 Douglas Place, Verona.
Now you can both raise your right hand. Do you swear or affirm that the testimony you each are about to give is the truth?
Yes.
Thank you.
Thank you. Sit down, have a seat, and tell us what you'd like to do.
I would like to put central AC units outside of our house, the right-hand side of our house.
Okay.
Excuse me, just when you're speaking, can you just turn the microphone on? Thank you.
Sorry about that.
What variance are you looking to seek?
Because we have a non-conforming lot, so our lot size is really small. The lot coverage right now is exceeded the max allowable amount. I'm not sure off the top of my head what that percentage is, but based on my house size, my garage, there's not really much more room for anything. So these two units I'm putting on the property will further make the percentage higher of the coverage. So anything that I'm going to put on my lot, anything, I will be here talking to you guys, unfortunately. But
For the record, you're in an R50 zone, which is typically 7,500 square feet.
But
5,000? Okay, and you're at 4,500.
And the improved lot coverage is permitted is 40%, it's 40% or 1,800 square feet. Existing on the lot is 62.4%, and the HVAC are considerably over already. So putting the HVAC down and bring them to 62.6% are 2,817.44. It would be in the denial letter.
Got it. And the proposed unit is 2 feet by 2 feet?
Yes, I believe so. Two units.
Mr. Chairman, while you're looking, just for the record, I reviewed the notice that was sent, and the application was deemed complete, for the record.
Just a question for clarity, when the lot coverage was measured, was that before or after the papers were removed? When the lot coverage was measured, was that before or after the papers were removed?
After the papers were removed?
I think after, because Kathleen, I think you remember I told you the papers were removed and you helped me with that. Yeah.
So that coverage is after? Okay.
I'm trying.
So by just taking a quick look at your survey here, so where these units are going to be located, your neighbor, let's say to your left, it's right up against their garage, and then their garage then comes the house, so you have a level of separation between.
Yeah, right to the, if you're looking at the front of my house, yes, the right-hand side is my driveway. Really, the units, it might sort of be, they'll be a little bit past the garage from where I think they're going to be. But
From where your neighbor's house, of your neighbor. So at least you have that type of separation between your space and your neighbor's space.
The driveway.
The
our
driveway, yes,
separates.
the driveway
Yeah,
separates.
So these would
it.
be butted up against our home. They won't be against anyone else's
Yeah, sorry.
property.
Yeah, so it's your home, your driveway, the neighbor's garage.
Right.
And then their home, so still.
Right.
Okay. And then you're currently using air conditioners all around your house, window units, so noise all around the house.
Right.
This would consolidate it to one specific point.
Exactly.
Where those units are proposed in your side yard, are they right in front of the basement window?
There's space to, I believe, put them to the right-hand side or the left-hand side. They can be put right in front of the window.
Okay.
Like somewhere in that patch of dirt.
And you may want to take care of that basement window because it looks like there's going to be a drainage issue fairly quickly.
We have plans to hopefully replace it
Okay.
at some point.
So it will be tucked into that area along the neighbor's driveway?
That's our
Your
driveway.
driveway.
Yep.
That's our driveway, yes.
Just for the board's knowledge, the end of the units to the neighbor's garage is 19 feet. And it is also possible, this would fall under the construction department, when units are proposed to a driveway, sometimes the construction department will require some type of bollard to make sure that a car going up the driveway or out of the driveway does not go into the units. But that would be a construction department decision.
Okay. Board have any other questions for this, the applicant? Seeing none, is there anyone from the public who has a question of the applicant? I'll move that along. Seeing none, is there anyone from the public who would like to make a statement about this application? Again, seeing none, for the record, I would move to board deliberation and ask, what are your thoughts on This particular one, which looks a little familiar.
I think this is a very reasonable request. It's an undersized lot. They're looking to add just the minimum amount of improved lot coverage for the pads. It meets the setback requirements and the noise level I'm not very concerned with, since there are window air conditioning units. It's all, this is right next to the house, and there's the driveway and then the neighbor's garage. So I'd be in favor of approving the application.
Okay.
I don't have any problems with this either. Excuse me, Douglas Place is quite remote, so it's not like this is going to be seen by the public or anything. It seems like a straightforward spot and a logical spot to put these, so I'm in favor of this.
Okay. Any other opinions? If I see no other opinions, Paul? Sorry.
And it does seem like it is, you said, the most logical spot to put them in the property, where, one, you'll be able to maintain them, as well as easy accessible for that type of work. So, yeah, I'm in favor of this application.
Good.
I concur with all of those statements.
Thank you. Okay, it sounds like we're in a position where I can ask if there is a motion to be made.
I'll make a motion to approve application 2026-15.
I'll second that motion.
Second. Thank you, Bill.
Can we add the condition that if the construction department requires the bollards, that the bollards have to be put in, so that we have it on record, and then the bollards are approved and it wouldn't require any additional coverage?
We can add that as a condition.
Can I ask, do we have to go through another variance for that?
No, that's what I was just saying, we added.
Oh, okay. All right. I'm sorry. Thank you for clarifying that.
So, motion is amended. Roll call vote.
Mr. Tully? Oh, I'm sorry. Dr. Cortez?
Yes.
Mr. Ryan?
Yes.
Mrs. Murphy Braddix?
Yes.
Mr. Mathewson?
Yes.
Mrs. DiBartolo?
Yes.
Vice Chair Weston?
Yes.
Chair McGinley?
Yes. On my count, that unanimously was approved. Enjoy your air conditioning.
Thank you, thank you.
Thanks for your time.
I would have thought that took longer. Okay, we move on to application 2026-12, 555 Bloomfield Avenue, and we'll bring up the applicants. And Councilor, I'd ask you to lead off for us.
Good evening. My name's Anthony Bocci. I'm from Bocci Law. I'm the applicant's attorney. I substituted in for the original applicant's attorney, Gatrione and Pamaco. I did not submit this application or the notice, but I did send in a notice of appearance subsequent to the application and the notice going out. And I appreciate the opportunity to present here tonight.
You get all that?
Yeah, you want me to, you said you wanted me to lead off?
Yes.
So as the board is aware, this is a appeal of the zoning officer Kathleen's decision with regard to 553, 555 Bloomfield Avenue. Hopefully everyone has read the memo that I prepared and has reviewed the resolution of approval that was granted to the applicant some years ago, to the owner of the property some years ago. The genesis of this is that the applicant contends that, and I don't want to speak for counsel, but generally speaking, the applicant contends that the current use of the property conforms with the resolution, and in the alternative, that even if it doesn't, that the applicant received approval from the prior zoning officer to operate the business. It is the township's position that the previous zoning officer did not have the authority to grant the approval because it was not consistent with the terms of the authorizing resolution. So Kathleen, if you want to now present briefly, because it's the applicant to testify of just the notice of violation that you sent, when it was sent, and on what basis. You can summarize, it doesn't have to be.
It's May 6th.
Sorry about that. Okay, so on May 6th, 2026, a letter was sent, and it was rescinding the approval granted by Michael DiCarlo, approving the Princess Themed Cafe, which has now also turned more into an event space. So the resolution 4555 that was approved and given to Mr. Valenti for the property said that the commercial tenant space on the first floor could either be retail, personal service, or retail service uses. A cafe and event space are not within those three categories. Now, a cafe or a restaurant would be a permissible use in the town center. However, this resolution says only 3 uses can be there, and it does not say that anything permissible in the town center can be there. It specifically lists these 3 out. Now, the other use that seems to have occurred is event space, where there are, princess-themed parties, but there are also other events that are taking place within the space. Event spaces are prohibited in all zones within the township. So therefore, that use cannot happen at all. And there was no approval for an event space.
Mr. Chairman, I know this is not something that customarily comes before the board. It is the applicant's burden to persuade the board that the applicant is entitled to continue to operate its business and that it conforms with the resolution that was passed back in 2020. This board acts in a de novo capacity. That means it does not take Kathleen's decision. It does not mean that the applicant has an easier burden. However, the burden is on the applicant to show that the applicant is using the space in conformity with what has been permitted.
And for the record, several of the sitting board members participated in that particular hearing. So, Counselor?
Thank you. So, although council indicated this, I'll repeat it from our perspective for the record. This is in fact an appeal under NJSA 4055D-70A from the zoning officer's May 6, 2026 letter rescinding zoning permit number 2022-275. The appeal application states the issue precisely, that the zoning officer's letter dated May 6, 2026, rescinding zoning permit 2022-275 was in error and should be reversed. That is the only question before the board this evening. Here's what the board will hear tonight. I will call one witness,
Martha Peralta, the managing member of Bella Princess LLC. Ms. Peralta will testify about what her business actually does, how it was described to the township in 2023 when the permit was issued, and how it has operated continuously for over 2.5 years without a single violation, summons, or complaint. And through her testimony, I have some documentary exhibits. I think you probably have most of those exhibits because it's the underlying variance application that was made in 2020, and then the permit that was issued in 2023, and then the letter from May 6, 2026, rescinding the permit. But through those documentary exhibits and the testimony of Ms. Peralta, we would respectfully submit to the board that the business fits squarely within the 2020 Board of Adjustment variance, which authorized retail, personal service, or retail service use on the first floor with no restriction on tenant type. Secondly, the zoning officer's characterization of this business as a bare event rental space, and that comes from the May 6 letter, I would respectfully submit is factually incorrect. Bella Princess is a staffed service business that provides recreation, entertainment, and food service. It's not a venue where people simply rent an empty room, which I think is what may be the perception of the zoning officer, but certainly we can dive into that tonight. And third, although council didn't refer to this, and I just want to note it for the record, my understanding is the applicable ordinance in question was recently amended in or about March of 2026, and it added, I believe, as a permitted use, commercial recreation facility as a permitted use. And I would argue, perhaps somewhat creatively as a lawyer, that I would argue that that category that the township itself added to the TC zone's permitted use, again, effective, I believe it's March, on E-codes it says March 9th, but in the letter it says March 30th. In the May 6, 2026, it says March 30th. I would argue that we actually even in fact qualify as a commercial recreation facility if you look at from a definitional standpoint what commercial recreation facility is as defined under your own code. So with the board's permission, I'd like to offer Ms. Peralta as a witness, and to the extent that you need to swear her in, I would imagine now is the time to do so.
Ms. Peralta, could you state your name and address? You can remain seated. You state your name and address for the record
Martha Peralta,
and the business address.
555 Bloomfield Avenue, Verona.
And will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth?
I do.
Thank you.
Ms. Peralta, what is your role with Bella Princess LLC?
I am the owner and the operating manager of the business.
And how long have you operated your business at the location here in Verona?
Since 2023, so about 2.5 years.
And are you familiar with zoning permit number 2022-2275, which was issued for this property in February of 2023?
I am.
And what did that zoning permit, what authorization did that zoning permit provide to you?
Basically what I asked for, I've been in business for over 20 years, and we do children's theme parties, and we asked for a permit to do that. In addition to that, because we had a really nice location, we also asked for cafe with limited food, which was also approved.
And Ms. Peralta, is it your understanding, or are you aware that the property in question benefits from a use variance that this board approved in 2020?
Correct, because it also had personal service, retail service, and that sort.
Okay, and I'm not sure if the board has that 2020 resolution. I have several copies of it, and I'm happy to provide it to you, but I'm going to read from the 2020 resolution where the board unanimously resolved that, and I'll read directly that, and this is a quote, the applicant's proposal to convert the second story of an existing building to 3 one-bedroom residential dwelling units and to use the existing commercial tenant space on the first floor for either a retail use, a personal service use, or a retail service use be granted. Were you aware that those were permitted uses for the first floor of this building?
I was.
Okay. And is it that variance is that what allowed the commercial use on the first floor, retail, personal service, and retail service use?
Correct.
Okay. And did that 2020 resolution also find that the uses proposed for this first floor are namely retail, retail service, or personal service uses, and they are all permitted uses in the TC zone? Is that correct?
Correct.
Okay. Now, when you applied for your zoning permit in 2022, what did you tell the township your business would do?
Exactly what we do, the theme parties as well as a limited use cafe.
Okay, and did you submit an application?
I did.
In 2022 for the zoning permit?
Correct.
And did your application specifically indicate that the permit itself was seeking permission for a business that hosts private theme parties and provides limited on-site food and beverage service for parties and to the general public as well?
Yes, correct.
Was all of that made clear was it also made clear to the board that there were no plans or intentions to operate a full commercial kitchen?
Correct. We didn't want to do a full kitchen.
Was that a concern of the board at the time that you had appeared? Were there questions from the board with respect to?
There was a
whether or
lot
not-
more questions.
Just let me finish the question. It's okay. Were there questions from the board with respect to whether or not you were going to operate a full commercial kitchen?
Correct.
Okay.
Counselor? Never came to the board.
I'm sorry?
It never came to the board.
It never came to the board?
Nope. Kitchen popped in the middle of 3 stories above, and the Wells Fargo rotating money
ATM?
machine.
Okay.
The board hadn't seen anything that connected those two.
You never testified as to anything with respect to a lack of a commercial kitchen at the...
Well, the lack of, we weren't seeking for a commercial kitchen.
Okay, but just to clarify, did that come up, I just want to clarify, I understand your position, did that come up in your application before the board?
The fact that I was not seeking
Yes.
a commercial kitchen, I don't believe so. We
Okay.
just said, yeah.
Thank you.
Well, you never appeared before this board.
Correct.
So in 2020, that was the owner of the building.
Yes.
Correct.
Yeah, so that was before it was rented out or anything of the sort. So we've never heard anything associated with the Princess Bella Cafe. This board has not.
Correct.
Correct. It was in 2023 that she ultimately sought the permit and got the permit from the zoning official. Is that correct?
But not this board.
Right.
Not this board.
Correct.
Thank you. And what ultimately was the zoning officer's determination when you submitted the permit application?
They approved it.
Okay. Talk to me, or advise the board, excuse me, specifically about what happens at Bella Princess. Describe for the board what a typical day looks like at your business.
Okay, so we do 90% of it would say children's parties. They're fully staffed. We have a party director, we have costume characters, we have assistants, we have someone that basically serves the pizza, the juice, and so forth. It's back-to-back activities for 2 hours, and we have several of them. And because it's usually a birthday party, they happen on the weekends.
And do customers provide their own outside vendors or decorations, entertainment, or their own programming in the space?
No, we provide everything. We call it the all-inclusive princess party, although we do other themes as well.
Okay. And is that the service that you provide to your customers?
Correct. That is the full service that we provide to our customers.
And is the customer purchasing the entertainment and party experience that is provided by your staff?
Correct. They're purchasing full packages through us.
And is it your testimony here tonight that they're not simply renting a room and bringing in their own things?
Correct. We never we never rent a room and then just have them use the space for whatever it is that they want.
So you're familiar with like a VFW hall where any, member of the public can rent a VFW hall and have their own party there. Is what you operate at Bella Princess close or akin to renting, say, a VFW hall?
Definitely not. We have very expensive items and we want to keep our place very pristine, so we never rent it out just to someone that's looking to do whatever it is that they want.
And does Bella Princess also operate a cafe?
We do.
Is the cafe open to the general public?
It is open to the general public when we have it open.
So the general public can walk in, sit down, purchase food and beverages, whether or not you're there for one of these themed parties?
Correct.
And is that what was represented to the township in your permit application?
It was. It was something addition to, since our bread and butter and where I have been doing business for 20 years is the themed princess parties. But we wanted to also be able to do the Princess Cafe.
And how many staff members typically work at the business on a given day or during an event?
Right. It really depends on the number of children. We max out at 20. So if we have a party that has only 8 little kids, then we might have just 3 staff members. But if we have 20 kids, we consider that a full house. So we might have 4 or 5, 6 people working, 6 staff members working that particular party.
With respect to these ticketed events that you just testified to, those are open to the general public?
It is.
Okay, and walk the board through how it takes place. Is it true that families purchase tickets and your staff runs the entire program?
So this is the recreational portion. We might host a Princess Tea Party, and then I'll sell tickets to the public, and usually it's through our social media. They buy tickets, and then I make sure that I have the characters there. They put on a little show, and then after the show, depending on the type of an event, we might either have crafts for the children to do, or we might do a little tea party. And usually they last anywhere from an hour to an hour and a half. Again, if back-to-back activities, we might have some story time, some dancing with the children and so forth.
And moving on, you received the May 6, 2026, what I'll call rescission letter from the zoning officer, true?
True.
Okay, and that letter specifically indicates that, let me find it, Mr. DiCarlo's action, and Mr. DiCarlo was the former zoning officer that approved the permit application in 2023, is that right?
Correct.
Okay. The May 6, 2026 letter indicates Mr. DiCarlo did not have the authority under the municipal land use law or the applicable township ordinances to approve the space for use as an event rental space, as that is not a permitted use. Ms. Peralta, is your business an event rental space?
It is not. We never rent a space as a raw space rental.
Do you provide a service?
Correct.
Can you explain to the board, maybe you have already, but be brief, what is the service that you provide?
The service is entertainment. The service is basically having a beautiful venue with characters and party directors, that we call them, to run a party for 2 hours with back-to-back activities.
Do you advertise or hold yourself out as a venue where people simply rent a room for their own event?
We do not.
Have you ever been a bare event space venue at any time since 2020?
We have not.
Is the cafe open daily?
The cafe is open on, because we are a children's event, during the winter, we open usually on the weekends or when school closings and so forth.
But the cafe and the space is open to the general public, true?
Correct.
Okay, and does the public pay a fee for your services?
They pay a fee when we have the ticketed events or they're having a princess party. And of course, they would pay for coffees and pastries when they're coming into the cafe.
Okay. Would you describe what you provide as both with respect to the private party booking, the ticketed events and the like, and the potential purchases that can be made at the cafe? Would you describe that as providing recreation and entertainment services?
Definitely.
Okay. Members of the board, I'll represent to you that Verona Code Section 150-2.3, definition of recreation facility commercial, defines it as a recreation facility operated as a business and open to the public for a fee. A commercial recreation facility may include, but is not limited to, the following uses. It says is not limited to the following uses: health clubs, day spas, gyms, and fitness centers. Ms. Peralta, based on what you have just told the board, is Bella Princess, in your opinion, a recreation facility operated as a business open to the public for a fee?
Yes, it is. In my opinion, that's what we do.
Let's speak briefly with respect to your operating history over the last 2.5 years. And I apologize. I know this technically may not be relevant to the board's consideration, so I'll be brief, and if you need to cut me off, feel free to cut me off. But has the township ever issued you a zoning violation in the 2.5 years that you've operated?
No.
Has there ever been a summons of any kind?
No.
Has there ever been a complaint that's been issued against you?
No.
Have you operated over 2.5 years without a single issue until you received the May 6, 2026 letter?
Correct.
Okay. Are you aware that in November 2024, this board heard an application for a Wells Fargo ATM at the same property?
I am aware of that.
Okay. And did the board's resolution in that matter make specific reference to the fact that the first floor is occupied by Bella Princess Cafe?
Correct.
So the board was aware of the business, acknowledged it in writing, and raised no objection of it being there at that time?
Correct.
What did you do in reliance of the 2023 zoning permit that was issued to you?
Well, once we received the permit, we went ahead and we had a full build out. We hired people, we decorated, and we prepared to open for business, and then opened for business, of course.
Did you sign a 5-year lease for the space?
I did.
Did you personally guarantee that lease?
I did.
So does that mean you're personally liable if the business can't meet its obligations?
I am.
Okay. What would happen to you and your business if this rescission is upheld?
We would have to close our business.
Would you lose everything that you invested in over the last 2.5 years?
Yes, not only monetary, but reputation. We have parties and we have events on our books.
Would your employees lose their jobs?
And they would lose their jobs, of course.
Counselor, I think you may have heard me previously say, family and finances do not come before the
I
board.
understand. I'll move on. Thank you. Is there anything else that you'd like the board to know before they ask you any questions or open it up to the public?
Just that, like we mentioned, I've been in business in this particular location for 2.5 years. We have nothing but positive reviews. Many mothers and families have told us that we are an asset to this community. Like I mentioned, we offer many different recreational activities for the children, whether it be a craft, whether it be a meet and greet with the princesses. So I don't understand where this is coming from. I mean, this is my livelihood, and we've done nothing but bring joy to these children and to these families. That's all I would like to say.
Chairman, members of the board, thank you for your time. I would respectfully submit Again, the only question before the board here tonight was the zoning officer's May 6, 2026 rescission of zoning permit number 2022-275 correct? And we would respectfully submit that it was not. And I would start with the 2020 variance, a variance that this board approved unanimously. And the resolution authorized the first floor for either retail use, personal service use, or retail service use. Those three categories were stated in the disjunctive. There is no restriction on what type of retail, personal service, or retail service business that could operate. There is no condition that I'm aware of requiring the tenant to come back before this board, and the only conditions were, well, I'll just leave it at that. If we look at the 2023 permit, I would respectfully submit to you, the permit application, I would respectfully submit to you that the permit application is consistent with, and what was represented there was consistent with how the business is operated to date and consistent with Ms. Peralta's sworn testimony here tonight. So we would respectfully ask the board to find that there was an erroneous interpretation by the zoning officer and allow this business to operate in town and to continue to provide the service that it does to your community. And I think it's an asset to the community, and I think we can fit it, within the permitted use that was granted to it under the original permit, or likewise argue under the revised or the amended ordinance that this fits even under that rubric as well.
As I said, I have had the pleasure of being the chairman for all previous 555 applications. And when we made the decision on the original application as to what would go upstairs and downstairs, at the time there was a nail salon and an empty space that was described as retail. It was our intention to keep it that way. When we got to the hearing for the Wells Fargo machine, there was a disjuncture. They had cut the space, the retail space for the nail salon in half, and there was no explanation as to where that came from. It just picked up, as we do, picked up with that machine. So where this came from, it was not, at least as a member of this board, it was not my intention when we very specifically said what could go on this location. We were doing it in conjunction with our master plan, which encouraged walk-in traffic, some sort of a retail venue that would involve walk-in traffic. So I think that was the original intent. And the zoning officer who was granted this particular variance, granted their own approval, was relatively new. And did not stay long. In addition, I don't believe the facility is of a recreational nature. I mean, recreation is a broad category, but I would say using the not limited to, but health clubs, day spas, gyms, and fitness centers is a bit off the trail of a princess event.
Well, can I respond to that, or?
You certainly can.
I'm just going off of what your own definition of recreational facility is under the code. And again, for the record, that is a recreation facility is operated as a business and open to the public for a fee. People can walk into the cafe and purchase
Coffee, pastries, etc.
when the cafe is open. So there is a walkable element to this, separate and distinct from the princess-themed parties that were made very clear in the application that was submitted to the township that was ultimately approved. And then my client reasonably relied on that approval and invested a significant amount of money, effort, personally guaranteed a lease. She's on the hook and operated for 2.5 years. I'm unaware of any issues, and I would respectfully argue that your own definition indicates that a commercial recreation facility may include, but is not limited to. So those following examples of health clubs, day spas, gyms, and fitness centers are not limiting in nature. Your own definition indicates that it is not limited to that, and I would say that in the modern economy, that these types of venues are popping up all over the place, and I would argue that I think there's a good argument that this type of facility would in fact fit within under your own definition, specifically because of how it's not of a limiting nature in terms of how that's defined. And I would indicate that, you know, there should have been an analysis, respectfully, I would say, in that May 6th letter. It references commercial, retail, recreation facilities, but there's no analysis with respect to whether or not this business fits within that definition. I understand that the examples that are used in there are not akin to what she's doing, but your own definition indicates that it's not limited to that. And in fact, we fit within the definition because we're open to the public and we charge a fee. And you can walk in, walkable, come in there and, you know, be across the street at Verona Park and say, I want to get a coffee or I want to get a Danish, and you can do that. And that you know, so that's the argument that I'm making.
While you bring that up, what are the regular hours?
The regular hours for the cafe is usually during the week, Thursdays and Fridays, Saturday and Sunday. When we have events that are open to the public, they could also come in. And then we also have parties on the weekends with the princess parties.
Is it Thursday and Friday with reservations?
I'm sorry?
Thursday and Friday with reservations?
We were taking reservations originally so we could see how many people we were expecting, but then we got rid of the reservations just because it wasn't something that people wanted to do, so then we just opened it up without reservations.
Mr. Chairman, if I could ask for clarification, because I think this is a very important point. If I'm understanding you correctly, when you are hosting one of these children's parties, okay, once again, you are in control of the party.
Correct.
You and your staff, okay. And the members of the public can still use an accessory area to that,
Well,
for like a coffee or a Danish?
Well, there's two spaces, like you mentioned. There's a space that, according to me originally, when he was renting them, it was 553, and the other space was 555. And originally, we were only looking at one space. Then he mentioned that he was having the ATM in front of the 555. And he goes, if you want, I could rent you the back end as well. And the back end, we do the back-to-back, the all-inclusive princess parties. And then the cafe, we call it the cafe side. That's when we have it open to the public when we do have it open to the public. And then we have ticketed events. And then, of course, we close it then and we open it to the ticketed events.
Okay, so it's never simultaneously open to an event or the public, it's either or?
Correct, right.
Okay.
So, yeah, and I appreciate the good explanation on the involved children-based parties and what's offered to the community at that point. Can you explain what a 60-person corporate office private party is?
Okay, so during the week, since we're not busy, so then we do offer it. To be honest with you, we haven't had any corporate.
Well, you still offer it. So
Yeah.
can you explain what a 60-person corporate
So-
private party is.
We create a menu, and then we welcome corporate or, we also do, when I said 90% of the children, we also do baby showers and bridal showers. And we do that on the weekends as well.
And can you go into detail as to what is involved in the delivery of that?
Okay, so again, we have staff there, we have a party coordinator, we have also someone that's working behind the coffee bar, and then they could also have add-ons. We have a vendor that does balloons for us, so we offer that to them, and then we have a barista that can be added as an extra. We also have hostesses that if they want us to also run the games and all that stuff, we can do that as well. But there's always at least 2 people running that particular event.
But at a bare minimum, they could merely just rent the space and just have people there present in the background, but it would just be a space they would have.
Well, we always offer packages.
It's offered, but they don't have to take the space.
Well, the
packages.
package includes, it's not limited to, but it does include the space. It includes a flower bar. It includes a coffee station.
But to follow up on Doctor's point here, and I think it's a valid one, if someone just walked into you and said, I just want to rent your room, okay, for a party, and I don't want any of your products, do you allow that?
We don't. We actually had somebody looking to do an 18-year-old party, and they wanted to bring a
Because in
DJ.
my mind, that's what I'm wrestling with, and I'll be very honest with you. An event space versus a retail rental seems to be, part of the crux of what we're talking about.
No, go ahead.
Oh, well, I was going to go off on a tangent. I don't know if you want to.
Go ahead.
Okay. Okay, so I was on the board as well for all of these previous applications too. And I pulled, because all of this is online in terms of the archives and whatnot. So the original application that came in March of 2020, the building code data was categorized as a B use and an R2 use. Okay, so that was the 2020 application. And then came along 2024, which was the ATM. And it clearly shows on this plan the extent of those 2 spaces that you just made reference to. In between that time, there was some sort of permit issued, there was some sort of a fit-out drawing that happened from your architect or whoever that was. So my question to you is, what is your maximum capacity? Because we have to look at not your operations, but the land use, like literally how people use the land. Because if you have a maximum occupant load of 50, plus all these deliveries and staff and whatnot, that's like 50 cars that we have to accommodate. And this is a very tight spot in the center of town. So I think that's part of what my concern is.
Okay. So when we did receive 2 maximum capacities. The town, I guess, saw it as 2 different areas. So we have one that says 79 people for the cafe side, and then it says 49 for the internal one. But because we do children's events, and we never, as you could see, we put 60, but really it's more like 50. And on the other side, we do max 20 kids and like maybe 20 adults.
And I think one of the main differences between the commercial, whatever that was,
Recreational.
Thank you, commercial recreational facilities, is that people can come and go whenever. In your case, people come and go at once. So all of those cars will park somewhere all at one time. And I think that's a significant difference between the 2 definitions.
Okay, yeah. They have a window. Usually they come within a half an hour of when it starts. And then, of course, we do guide them on our tickets and stuff. We guide them to the municipal parking.
And where do they park? Do you know?
We tell them to park behind the Chase Manhattan Bank, which is supposed to be the municipal parking. That's what we guide them to.
Do you have a health permit to sell the food, pizza and coffee?
We do.
And My understanding, if you're a food service, a restaurant, cafe, you still would not fit in retail or retail services.
That's what I was just going to ask counsel. If counsel, is it your contention or your client's contention that that acting as a cafe open to the public and as board member just asked, Mr. Wesson just, Mr. Tully just asked, you're selling pizza, you're selling coffee to the general public. So counsel, I'm curious as to how that fits into personal service establishment, retail service use, or retail use.
Yeah, I mean, the personal service use, I think, is more aligned with the services that are provided by the themed parties and the staff that run those themed parties. That's really where I was going with the personal.
Well, wouldn't you argue, or how could you, or please, like, convince the board that selling coffee and selling pizza and grilled cheese and pastry delights conforms to the approval that was granted?
Yeah, it conforms to the approval that was granted because I think the original permit application indicated specifically that they would be providing light food and fare.
Yeah.
I'm talking about the 2020 resolution.
Yes. Yeah, I'm talking about the 2023 permit application.
Right, so we agree that the 2020 resolution, that this does not, the use now doesn't conform to the 2020 resolution?
No, I don't agree with that.
Well, so then how does serving coffee and sandwiches to the general public conform, in your opinion, to the 2020 resolution, which allows personal service,
Yeah.
retail use, retail service?
Yeah, I think when you look at, I don't think you can look at it in a vacuum in terms of the services that are provided there. The services that are provided there are themed parties. That's the service, right? You're coming there. There's professionals there. You want to call them professional princesses that are there that run a party. And in connection with that, there's some food that's offered in a separate space. So I don't know that those are really mutually exclusive.
Well, the food is offered to the general public on a walk-in basis.
Yes.
Okay, so you would agree, I would think, that that is a restaurant use or it's certainly not a personal services use, a retail use or a retail service use.
I don't know that it's technically a restaurant use because I think
Cafe?
they can only have like, what type of ovens do you have? You don't have any real ovens, you just have,
The Magic Chef, the Mary Chef.
stuff that you use at like,
They sell pizza.
yeah, like a Starbucks.
Can
where they
I
heat
ask a
stuff
question
up.
though? So in the permitted uses under the town center zone, even from the 2020 time period, full service restaurants, even snack bars, et cetera, are permitted uses. It's just
But
that
they're excluded based upon this resolution.
in the resolution. Okay.
Right, they
Okay.
agree to limit their use of the property.
Even though it's a,
Because as a trade-off to getting the second floor for whatever, you were on the board then, but that's why we're focusing on the 2020 resolution. Okay, and then, Mr. Chairman, I also, do you have a website?
I do.
Okay. Does your website, is it current?
Yeah, I mean, my main website is bellaprincess.com.
Okay. Your website says that someone can transform the space into an exclusive event space. So I thought it was your testimony that it's not used for event space.
Well, terminology, the same thing like when I advertise princess parties ideas, people to come to me. I don't sell them the ideas. I sell them a package. I sell them, what we do.
Okay, so when you have, as part of your website, experience the charm of La Bella Cafe after hours, transforming into an exclusive web space in Verona, whimsical cherry blossom theme and elegant raindrop pendants, it's perfect for hosting up to 50 guests. That's not We're not talking about princesses.
No, I also do bridal showers and baby showers.
So that's exclusive event space. So would you like to retract some of your testimony before?
Well, because we're also offering party planning. Like, I don't, maybe I don't understand the difference about, just a raw rental space like a BFW and what we do. We truly are a service-related company,
But you do weddings, you do showers?
baby showers and
Baby
bridal
showers
showers.
and wedding showers?
No, yeah, bridal showers, correct.
So would you call that event space?
I mean, if that's,
They're not princess themed. right?
no, they're not princess, I mean, they could be. We actually had a Snow White at one of our bridal showers, so they could be. A lot of people are Disney obsessed.
So office gatherings?
Yeah, office gatherings, we can also, yeah,
Okay,
I do advertise that.
That would be
Yeah.
event space? You agree?
Yeah, I mean, if you're talking about just event space versus a raw space,
Right.
we do, at least we offer. We haven't done it yet, but we do offer the space so we can help you
But
plan.
before you said you don't use the property as event space.
Correct. I don't understand exactly your terminology versus event space versus, let's say, a BFW. We are
But
not
the
that.
question was, do you use it for event space? And you said no. So whether you for whatever you understood the terminology, you said no.
Okay. So how I understood it,
Okay. Well, thank you. Can I ask a question?
Sure. What percentage of your business are these themed,
bridal showers?
no, themed princess parties versus what council was alluding to in terms of bridal showers or office parties or anything of that sort? From a percentage perspective, how much of your business is what council is alluding
So,
to? Just
90
answer that question.
90% of our business is children's parties, children's entertainment, and so forth.
So if the board has an issue with respect to you having bridal showers or office parties or anything of that sort, which seems to be a small portion of your business or significantly small portion of your business, is that something that you would be willing to concede moving forward?
We're not hearing a use application. This is we're here to basically decide on the ruling from the zoning officer.
I'm just trying to.
I understand, but that would be an option depending on, what the board feels that there could be a use application put through.
Fair enough.
So do we define event space in our code?
You do.
You do have a new one.
And I had it, but I lost it. But you do. Give me 1 minute. Event space, do you have it? Okay, sorry.
An event space, a commercial venue available for rent, private group, or individual to conduct an event where the purpose of the event is unrelated to the approved use, to obtain secondary use approval as an event space and shall meet the requirements of both an event space, and any of the underlying principal approved full-time principal use where an event may be hosted that is accessory. Sorry, it seems to be cutting out words, I'm sorry. Yeah, it's cutting out words.
I have it here printed if
Oh,
you want to
this
read
one's
it.
a little, this is it, okay. A commercial venue available for rent or that may be otherwise retained for the exclusive purpose of hosting a planned activity scheduled to occur at a specific time, such as a wedding, birthday party, or business conference. Alternatively, a venue that may be rented to a private group or individual to conduct an event where the purpose of the event is unrelated to the approved use of the host venue and is therefore not accessory to the underlying principal use, is required to obtain secondary use approval as an event space and shall meet the requirement of both an event space and any of the underlying principal use. Excluded from this use are locations where there is an approved full-time principal use where an event may be hosted that is accessory to the principal use, such as a book signing event at a bookstore or a private dinner party at a restaurant. And also noted, event spaces are prohibited in every zone.
So council, now hearing that definition, how would you like to kind of comment how this business does not fall under that definition? And if so, what definition would you still contend it falls more so under the commercial recreational facilities?
Yeah, under the current code, and I would argue that there is the, at the end, it indicates excluded from this use are locations where there is an approved full-time principal use, or an event may be hosted that is accessory to the principal use. I'm not sure that exactly fits here. Under this construct with the 2023 permit, but the permit gave her the ability to host these themed events. I would argue that, that definition is excluded from the permission that was provided to her under that permit in 2023. That's really the principal use of the site, at least from the application that was submitted by her to the township.
And so, as far as the previous zoning officer, so an event space is prohibited in every zone. It was never allowed. Therefore, he did not have the authority to grant that approval. The only people who had the authority to grant that approval is this board through a variance process. So he didn't have the authority to do that, nor does anyone else in the township other than this board.
Again, just because I want to be able to ask a clarifying question. I wasn't on the board when this, or whatever. I mean, just sticking to those two packages that are offered. One that was very well explained at the beginning during testimony, one that I asked about thereafter. When Bella Princess Cafe initially opened up, were both of those packages initially offered, or was the Princess one the one that was offered at first, and then the other one kind of came into fruition later on as an expansion?
When you say the other one?
There's the Princess parties, right? That is core, what it felt like through your testimony was a core function of it. Princesses offering, delivering, whatever, doing their thing, their magical stuff. And then there's the other one, there's a private party,
The bridal showers and the baby showers.
office parties, private parties type thing, setup basically. Were both of those offered from the get-go, or was the second one added to kind of fill the gaps?
They were both offered.
Thank you.
What were the open to the public hours when you first started the business?
10 to 3?
Every day?
No, a few days during the week, and then I believe it was also on Sundays.
All right. Oops. Okay. Since there's very few rules for how this goes, are we comfortable identifying what the Bella Princess Cafe business plan is, current business operations are? Do we have a clear picture of that?
I think it's an event space. I think when you are, I mean, there's multiple things wrong, because you're also considering yourself a cafe, which is a food establishment, which doesn't belong there either. You brought up like an exercise place that has like a bar inside, or sells food or drinks or whatever. But that is an accessory to that exercise place. They can't actually sell it out to the public. They're not allowed. It's technically only for the customers that are in that exercise, or that exercise. So, and I think the only time that food and beverage is allowed in a space is either if you're a restaurant or food establishment, or an event space. An event space allows you to do food. So just by those two definitions, neither one of those fit in the space.
Okay. If we're comfortable with that as an understanding of what the operation is it in conflict with the 2020 resolution authorizing the variance for this property?
I think it is. Yeah. I don't see that the actual use that we've just ascertained fits within a retail use, personal service use. Or, yeah, or retail service use. Yeah, no, I don't think it falls within that.
Okay. Kevin?
Well, basically, I don't know whether I'm maybe poll the board members who are here who, passed the resolution in good faith. They I seem to get the impression that the retail space was limited to basically some type of business that opened and sold goods or services, on an ongoing basis. Would that be an accurate description of what your intent was?
So, as being one of the members that was on the board and heard that application at the time, from my recollection, is the applicant proposed to the board that they wanted the mixed-use variance. And with that, so it's the apartments on the top floor, and with that, they proposed the retail services and the personal services to us. And that was similar in nature to how that space was being used previously on the first floor. But they wanted to add the apartments on the
So it seems to me that the applicant is more or less, and they can correct me if I'm wrong, saying they're providing a personal service, and not necessarily purely event. That's your contention? Or you're just basing it on the fact that you went to the zoning officer at the time, the zoning officer gave you a permit.
Correct.
Which it seems to me did not, when he issued the permit, he sort of violated the intent of the resolution at the time by, allowing you to operate not as really as a retail operation, unless you're saying. He just sort of gave you the permit. Do you recall any discussions with him, or do you have to submit a formal paper application? Do we have any documentation? It exists?
Yeah, I have the application that was submitted, and I have the approval from the zoning officer that specifically makes reference to the 2020 variance application and says that personal service runs with the land, and that we're approving this application.
That's the point I'm getting at. He
did the analysis.
He based upon it being a personal service.
Well, I'll pull it out, but
I would like to know.
He referenced.
Would you like a definition of personal service?
Well, can I just provide?
Let him
Can I provide
Sure.
the answer first?
Then you can clarify.
So it's a February 10th, 2023 letter that was revised February 22, 2023. And in the zoning decision section, would you like me to read it to you? I have copies, I can give it to you as well.
It's in your packet.
Mr. Ryan, you have a copy. It was
It's
given
in your
as part of
packet.
the
Okay,
package.
all right, so he referenced that,
Yeah.
but he references that, he's considering it a personal service.
He doesn't
Yeah,
make
but-
specific mention to the personal, he lists the 3 approved uses on the first floor as part of the mixed use.
That was from, I'm sorry, you're right, that was from 2023.
Can I read it for the record? If you don't want me to, I won't, it's okay. I mean,
You know, those of us who weren't there in 2020, I would like to just.
Yeah, so,
23 for that.
the zoning decision in part reads as follows. This office has reviewed the applicant's request for zoning approval and has found that the proposed use does fall under conditional uses for the TC zone since it does comply with the standards set forth under section 150-8.3 pertaining to conditional uses. However, this property had already received prior approval by the Township Board of Adjustment for a variance pursuant to NJSA 4055D-70D3, which granted the owner of the property permission to use a lower level first floor for retail, personal service, or retail service use, and the second floor for residential apartments. This was approved on August 13th, 2020, and memorialized on September 10th, 2020. Since the variance runs with the land, the resolution of approval by the Board of Adjustment Office has approved the applicant's request to operate a mixed use at this location. The applicant has not submitted any zoning request for a business sign. A zoning request must be filed and approved by this office prior to the placement/installation of any business sign. So that's the analysis that was done.
So what did the applicant list at that point in time that she was going to be doing when he granted the approval for? What was the?
Private theme parties. Food and beverage are provided from an off-site caterer. No on-site preparations proposed at
She
this
was
time.
upfront in terms of what?
100%.
So this,
Questionable with the food, but with the parties, it was up.
I believe that the applicant, and I can pull it out, but I believe the application specifically references light food, not questionable. It's specifically referenced in the application, so she was upfront, 100%.
Okay. It would have to fall under the auspices of personal services in order for him to grant the permit.
Correct, but that's also
Would
what
you agree
brings,
with that at least?
yes, but that's also what brings us here today.
Yeah, okay, but I'm just saying, that's.
But, yes, personal service establishment. An establishment providing non-medical services to individuals as a primary use. Examples of these uses include but are not limited to barbershops, beauty salons, day health spas, hair salons, nail salons, tan salons, foot spas, massage parlors, aromatherapy and reflexology establishments. Tattooing and other body modification establishments do not constitute beauty services.
So we provide a non-medical service for a fee.
I think the operative word is individuals. So you're providing a service to whoever you have a contract with, but all the other people you're not providing a service to.
I don't know that I agree with that, but.
Council, like, we heard the definition of event space, and we just now heard the definition of the personal service. Can you please make your argument as to why it falls more so into the personal service or retail service, one of the approved uses, as opposed to the event space?
Yeah, as I indicated before, if just looking at from a strict definitional standpoint, she fits under the definition of a personal service as reflected in your own definition. It's non-medical, and it's a service that is provided. The service that is provided is you're coming to the space and there are professionals who are there who run a party as princesses and the like, or whatever other, themed parties that professionals are at. That is the service that is being provided to members of the public that can walk in, utilize the cafe, or be part of these parties or events that are open to the public. It's not just private parties, just for like a birthday party, so to speak, for a little girl. It's also ticketed themed events where anyone from the public can come to the space and obtain that service that is being provided. That's why I would argue that it does in fact fit under what the original zoning officer found at that time in 2023, relating back to the 2020 variance application. I hope that answers your question.
Well, I mean,
That's the best answer I can give you. How's that?
but that's also what, you're basically asking the board to interpret,
Yes.
that as opposed to our, our zoning officials' interpretation.
Yes, yes, sir.
So like for the idea of a personal service, I guess in your mind, is that one person comes up to hire you to basically entertain a group of people through this party. So it is, and there is a personal aspect to it as we're trying to like make this into an event space or stuff. You are creating you're creating something for that person to experience, something that they want to experience. And yes, it involves a whole group, but is that, I don't know. I do find that under a personal experience. I may be stretching it myself, but.
But that's why I wanted to clarify, and I've asked this multiple times. Yes, I understand that, but it is very much part of the operating model that the customer can opt out of that. It is not a requirement that that personal service be delivered.
Not, but 90%.
But it is, the customer has the option to opt out of it. It is not a requirement as part of the business operating model that the personal service be delivered. Like that, the personal service is not a requirement as part of the operating model. That's what I've been asking from the beginning.
No.
I don't know how else to ask the question.
Yeah, look, I don't know, based on the testimony that I've heard, which is fairly consistent, this does not fall under personal services. Based on the definition, based on the testimony of the actual use, it just doesn't fit. It's an event, it's an event space.
And again, regardless of what kind of event it is, this, Princess, is not whether you engage with those services, you're still bringing X amount of people to this site. Again, we're a land use board. How's the land used? Right? That's what we're here to interpret.
I understand what you're saying. I mean, from a land use perspective, it's like a retail service or personal service, if that were the main function of it. But the fact that they can opt out of that, that's a concern that I have. That's why I guess I'm just trying to.
So are we at a point where we can either say that the zoning officer was within his scope of interpreting this to be consistent with the 2020 resolution, or are we saying that it was not it was not that zoning officer's prerogative to interpret it wrong?
My interpretation, not correct.
Okay. Okay. So what we're looking for is to see if we're looking to make a decision on whether the current zoning officer's interpretation and rescission of the permit is consistent with the original 2020 resolution.
Do we make a motion?
Yeah, we're going to need
Mr.
to.
Chairman, if you go to F1 of my memo, I think I set forth the sequence. The first question would be whether the cafe is operating the premises based on the testimony. What use they were operating the premises based on the testimony, that's one. Two, interpret the zoning ordinance and the resolution to determine whether the use falls within retail use, personal service use, or retail service. And then 3 and 4 are conditional. If the board concludes the use was within the scope, then you reverse the opinion. If the board concludes the use was not within the scope, then affirm the rescission and note that the previous approval was issued ultra vires and is void. So if you go to F and look at number 1, determine what use of the Bella Princess Cafe was actually operating at the premises, based on the testimony and the evidence. That would be the first question.
Can I ask one more clarifying question for myself, like for what was read earlier before we get into this piece, just for my own sanity? Is that okay? I'm sorry. Remember when the definition of, I think it was event space was read, and at the very tail end, it was like a restaurant holding a thing. If this were so, like, let's say they were only doing princess theme, like the princess theme stuff all the time, like a restaurant does restaurant stuff all the time.
So that's basically to cover a restaurant, right?
Correct.
So let's say a restaurant
Restaurant serves food all the time.
and you're ordering off of their menu, but the main part of the restaurant is a restaurant. So you can go and order off the menu, but you have a
But
group
you
of
have 10
people there.
tables for yourselves.
Right.
Someone could rent out the entire restaurant, but it's an ancillary use that's not in the normal course of their business.
That's okay. That's understood. I understood that delegation. Well, not part of this. Thank you. Sorry.
Well, you're not saying that if a restaurant has a private room within the confines of the restaurant, that's not considered an event space then?
No, it's considered a restaurant.
Okay, so it's just part of the restaurant? Okay,
If it's a one-off.
okay.
Yeah, I guess the difference for me is just having all of those people come at the same time and all those people leave at the same time. So I guess I make a motion to affirm the rescission.
Thank you. Can we have a second?
I'll second.
Okay, we have a motion and a second. To affirm the rescission note that the permit was issued ultra vires and is void, and advise the applicant that a use variance application is the appropriate path to seek authorization for the proposed use going forward. Do we have a roll call vote?
Dr. Cortez?
Yes.
Mr. Ryan?
Yes.
Mrs. Murphy Braddix?
Yes.
Mr. Mathewson?
No.
Mrs. DiBartolo?
Yes.
Vice Chair Weston?
Yes.
Chair McGinley?
Yes. By my count, that motion was approved. It'll be drawn up and drafted by our council, and we will vote on a resolution at the next regularly scheduled meeting.
Can I strongly recommend consideration that you go for a use application? You know, am I allowed to?
So I spoke with counsel before this. I wasn't the lawyer that handled this original application. We'll certainly consider doing that, absolutely. And thank you for your consideration.
I do have a question pending the operation. Not for this, right? Okay, that'll be me.
That's only you.
Thank you.
While the next applicant sets up, we will take a 5-minute break and resume here at 10:06. 2026-16, 111 Hillside Avenue. Applicant seeking approval to construct a new second-floor addition over an existing first-floor kitchen. And
Sir, could you please raise your right hand?
Yes.
State your name and address for the record.
My name is Tim Stillings. My address is 111 Hillside Avenue here in Verona.
And Mr. Stillings, do you swear or affirm the testimony you're about to give is the truth?
I do.
Thank you. Mr. Scott, you raise your right hand. Do you swear or affirm the testimony you're about to give is the truth?
I do.
And we know your name and address.
You do.
All right. Licenses are in good standing?
Yes, they are.
All right, so we'll skip the formalities.
Yes.
We'll accept them as an expert in architecture. All right.
The application was deemed complete. Notices are proper. You may proceed.
All right, good deal. Well, first off, good evening, everyone. My name again is Tim Stillings. My wife, Kate Felix Stillings, and I are the homeowners of 111 Hillside Avenue. We have resided in 111 Hillside Avenue since purchasing the home in August of 2011. So we're coming up here just in a matter of weeks on our 15th anniversary here in Verona. We're proud to be raising our kids in this house. We have two kids. Their ages are 13 and 10, although the 10-year-old is now starting to go on to 20, which is one of the reasons why we need to complete the addition that we are seeking to complete, which is our reason moving forward. As noted, the addition that we're seeking to complete is an addition to the rear of our residence onto the second floor to add a bathroom. We're looking to do so by building onto the existing structure. Specifically, the addition will go on top of our kitchen, where our kitchen currently resides. The reason why we were looking to do this, as just stated a little bit ago, I have two kids. They are getting older. In fact, they're moving on up into their teenage years. Plus, we have two working parents. Currently, we have one small bathroom there on the second floor. It is the only full-size bathroom in the house. With that, it is the only bathroom in the house that has a shower/tub for all four occupants of the house. With the plan, the addition plan that we have, what we sought to do is basically go about it with the minimum way to achieve the addition onto the second floor, while maintaining the style and unique character of our home, and is solely adding the bathroom. So the variance request that we're putting before the board this evening is related to our minimum side yard setback, as required of being 8 feet. Our existing and proposed is 5.37 feet. And then a variance is also requested related to the minimum side yard setbacks of both sides of 18 feet as required by the code. Our existing and proposed is 15.4 feet. That's the 5.37 feet on the side for which will be closest to the neighbor on the side that the addition is being built. And on the opposite side, it's approximately 10.114. With me this evening, as noted, is Evan Scott from E. Scott Architects. I'd like to turn it over to him to go over our addition plan.
Great. Thanks, Tim.
Thank you.
I took my job of telling you what the variances are, so I'll get into the proposed design. We're just renovating the existing kitchen, which is also a bump out on the first floor. And the goal was to create another bathroom. They currently have, like Tim said, one small bathroom on the second floor. They had recently done an addition last year to gain some additional bedroom space because the bedrooms were very small off to the side on their existing sunroom off to the side. So we talked and discussed where an additional bathroom might be able to go. The best spot we saw was on the second floor above that existing kitchen first floor bump out. We looked at cantilevering, we looked at full additions out the back, but they are maxed out and over on their existing impervious coverage. They're also maxed out on their building coverage. So we thought that the best route would be to just go over the existing first floor structure. The existing dwelling is currently over the setback line, so it predated the current zoning setbacks. The first floor, as well as the main structure, is over that 8-foot setback. So that is the one variance we're going for with regards to that. We had discussed and tried to step that addition back on the first floor because we were trying to avoid a variance if possible. But if you take a look at the second floor plan on A02, detail number 6, we are limited because the stairway is right up there to the second floor. If we were to step back, the door would then hit the vanity. We wouldn't have any space to get into that bathroom and have a functional restroom that we're looking to do. So this was kind of the minimum footprint we could do. We also looked at extending and cantilevering over the backside and the other side, but it created more issues with us from a zoning standpoint and also a construction standpoint. The house is a very unique design. It's a Tudor style stucco exterior, which you can see in the photos that we have provided. We're looking to maintain that, so keeping the same existing stucco siding, maintain the roof, and we're going to be providing a shallow roof structure on the upper section. You see in our model and images we have on the cover sheet and also here, we're doing a flat, mostly flat roof structure above to limit the amount of impact on the sun and shading from the adjacent properties, as well as not impact any existing windows on that second floor. We are preserving the existing yard areas that exist currently. We're avoiding additional impervious lot coverage. We are also protecting the open space that already exists currently on the site with the neighboring property. The existing house projects past our house currently at a same double-heighted story, so we are mimicking that side on the adjacent property. But by keeping the roof low, we're not changing any impact to the amount of daylight that gets on that side, as this is the south-facing wall. The variance we request does not result in any substantial impact, detriment to the public good, because we are keeping the impact to light, air, and privacy by not going further out the back, further out the side than what the existing one shows. We are also limiting the expansion to that side piece and limiting the amount of roof that we're providing over the top to limit the impact on the light in that area. Let's see, we're not any kind of doing any new non-conforming situation. We're kind of just making sure that the existing one does not change in effect. Any drainage that we have will be the same. We're using similar roof leaders in the same locations, just adding a roof above on that second floor and taking away that the existing one. So the site slopes to the street on the front and also towards the driveway side. So we propose to keep that exactly the same way. And I believe that is most of the designs we're doing. Yeah, the adjacent property was the one we were looking at as being trying least impactful there. So we thought that this would be the least impactful by also creating that usable, functional bathroom space above.
Are you adding a window on that side of the house? Is that the west side?
There are existing windows that are not shown on the front of the house. We will not be adding any windows.
Okay, so no potential privacy issues?
Correct, yes. Yeah, if I go back to the plan. Yep, it'll be the existing bathroom window exists in the existing bathroom. Any new windows will be on the rear facing of the property.
I should note for the record that Mrs. DiBartolo has recused herself from this application, so the record can reflect that. And just to confirm, does the existing shed stay?
It does. Yes, very functional and usable. We were talking about doing an addition to take over that space, but functionally and due to cost, the coverage, everything, it would be more impactful for that. We had to go for more variances.
I'm obviously pleased that that's staying. Where I had to keep some stuff.
I was just happy to hear that that wasn't some sort of a statement you were making with the two-color house.
Well, that hopefully will be resolved after we finish it all. To do the painting all at once, we had a little bit of a situation last year that caused some delays. But once we're through with, if this addition is approved, then we'll paint the whole house and hopefully it'll look better than ever.
Yeah, and stucco cannot be put up in the winter, so there's some urgency to get it done.
I have no more questions.
Anyone from the board have more questions?
I just was wondering if you got a chance, and although our engineering department was not required to provide a formal review, they did submit some suggestions. Did you have any opportunity to read them, or do you have any comments about them?
I have indeed received it, and I have read it. In regards to their number one point there, as far as whether or not we were doing any regrading, no regrading is going to be done. They did have as number two the proposed limit of disturbance. Please note if disturbance exceeds 2,500 square feet.
Which it does not.
It does not, okay.
And then the third one talked about whether there was any issues involving any flooding issues. Following Hurricane Ida, during Hurricane Ida, who didn't have any flooding issues, right? We did get water that came in on that side of the house. And so what we did was we put in French drains in the basement and also put in drainage on the outside of the house as well. Since we have done that, we have had no flooding issues whatsoever, no moisture issues whatsoever in the basement. And then
Just good from your own perspective, right? Yeah, sure. Okay.
Say again.
I said that was just something that obviously you needed to do for your own health.
Yes. Yeah, that was not a fun night at all during Hurricane Ida. And as Evan discussed, all the leaders and the rain spouts coming down are all going to be into the grass area. And then the as-built survey for number 5, that one I did not make a note of here.
Yeah, that's typically requested by them. So it'll be done.
Okay. And I always ask this question. I know you legally had to notify your neighbors with the certified letter, but did you have the opportunity to speak to your neighbors on either side of you, or just about what you were doing?
Yes, we spoke to the Pignatellos.
We're on the side closest to where the addition is going to be completed. We also spoke to the Blastros, who are on the other side as well. Neither one of them have any issues with us doing this addition and are supportive of our
Okay, I'd just like to get that on the record. Thank you. I have no other questions, Mr. Chairman.
Any other questions from board members? Is there anyone from the public who would like to ask a question? Seeing none, is there anyone from the public who'd like to make a statement about this application? Again, seeing no one, and those neighbors on that list are some pretty heavy hitters, so seeing no one is an important feature. I would close the public portion of the meeting and move to the board deliberation. And I would note once again, Mr. Scott, you are going to have to go to our council and planning board and see if you can't get them to change the ruling about the consistent level of the house.
I will do that.
Because they recently reaffirmed it, and it does make it very difficult for us approving variances that take a swipe at it. However,
I'm in favor of approving the application. I think the addition is of kind of, I would say, appropriate size. The location where it is seems very reasonable, given kind of the area of town where the home is located. Adding an additional bathroom is certainly desirable, fits within the kind of neighborhood context. The fact that there's no window being added to the closest neighbor on that side certainly, doesn't create any sort of privacy issues. So I'd be in favor of approving application 2026-16 as presented.
how about others?
I would second Mr. Weston's approval. I guess when we get to the point of formally doing that.
Concur. Everybody kind of head nodding, we're good, and you're not falling asleep. You're actually, okay. Then I think we're probably at a point where a motion would be appropriate.
I'll make a motion to approve application 2026-16.
For that motion.
Okay, second, third, we're going to need to vote on it.
Mr. Tully?
Approved.
Dr. Cortez?
Approved.
Mr. Ryan?
Approved.
Mrs. Murphy Braddock?
Yes.
Mr. Mathewson?
Yes.
Vice Chair Weston?
Yes.
And Chair McGinley?
In light of the council's recent decision not to put me into the temporary council position that would last until next November, I'm voting yes. By my count, that was approved unanimously, and the resolution will be at the next meeting, which I believe is August 13th. Okay, is there any reason to go into executive session?
No.
Then I would entertain a motion to adjourn. Wait, first, has everybody given their dates of availability?
No.
Not yet, I will. Yes.
Actually, I don't know.
When you pose your question,
I can take them tonight if you know, if not, if you.
What are the dates you're asking?
August 4th, 5th, 6th, or 18th.
I told you one, I'm not available.
Right.
Okay. I'm available for all those, but I'm not available for the next meeting on the 13th.
Are you serious?
Yeah.
Not available?
I gotta check to see if I come back from vacation.
I gave him enough, I gave him enough notice.
Let me make sure.
If not, it goes to.
First 2 weeks August, yes. Last 2 weeks August, no.
I am available. I fly back 2 days before.
Oh, perfect.
4th, 5th, 6th, and what? Sorry, 4th, 5th, 6th, and what?
my wife does too.
The 4th, 5th, 6th, or the 18th.
That's still there.
First week in August or the
Next to the garage.
Tuesday, I think it is.
I sent you an email today. I don't know whether you had a chance to read
Yes, I
it.
got that, thank you. I need Mr. Mathewson, if you know your availability, Mrs. Murphy Braddock, and Ms. Dr. Cortez, I don't know. Yes or no?
I can do the 4th and the 6th.
Okay.
Not sure about the 18th, but the other one I can't do.
Okay, 4th
Good
and
night.
6th.
Yeah, right now I can
It's a
afford
triple use variance.
It's a what?
A triple use variance. One building, 3 uses.
I take it back, I'm actually not available on any of these.
Wait,
Yeah, I'm available the 4th and 6th, 18th is questionable.
Okay.
do we get more points for a triple?
Yeah, we can adjourn, let's adjourn.
Mr. Chairman, I make a motion to adjourn.
Doesn't need a
Second, let's
second.
do it.
Doesn't need a second. It's good.